There are crimes that hide in the shadows, and then there are crimes that move comfortably through well-lit rooms. The Jeffrey Epstein case belongs to the second category, not because it was invisible, but because, for years, it was strangely tolerated, investigated, paused, redefined, deferred, not once, but repeatedly. The question is not why no one knew. Many people knew fragments. The quieter question is why those fragments never formed a whole until much later. This is not a story that begins with sex crimes. It begins with access. Jeffrey Epstein's early life offers little that predicts his eventual reach. Born in Brooklyn in 1953, the available record suggests a middle-class upbringing, unremarkable on its surface. He attended college briefly, without completing a degree. By his mid-20s, however, he was teaching at the Dalton School, an elite private institution in Manhattan. How Epstein secured that position remains unclear. There is no public evidence of formal teaching credentials. What is documented is that Dalton catered to the children of powerful families. Epstein was not wealthy yet, but he was observant. Students later described him as confident, attentive, unusually interested in their futures. He left Dalton abruptly in the mid-1970s. The reasons vary by account. Some suggest boundary concerns. Others point to administrative disagreements. The school has never offered a detailed explanation. Within a few years, Epstein reappeared in a different world altogether. By the early 1980s, Epstein was working in finance, first at Bear Stearns, where he again rose faster than his background would seem to allow. He was not a trader in the conventional sense. He was described instead as a consultant, someone who managed relationships. When Epstein left Bear Stearns, his career did not stall. It accelerated. He began presenting himself as a financial advisor to ultra-wealthy individuals. His firm, later known as J. Epstein & Company, claimed to manage billions in assets. Yet, public records list very few clients. Those who were named, most notably Leslie Wexner, founder of L Brands, were unusually generous in the authority they granted him. Wexner signed over sweeping power of attorney. Epstein took control of real estate, finances, even staffing. The relationship remains one of the least clearly explained aspects of the case. Wexner has stated he severed ties years before Epstein's first conviction. Why the arrangement existed at all remains unresolved. This pattern, extraordinary access with minimal explanation, would repeat. Epstein did not live discreetly. He accumulated properties that were not merely expensive, but symbolic. A Manhattan mansion near Central Park, a sprawling estate in Palm Beach, residences in New Mexico, Paris, and a private island in the US Virgin Islands. These were not private retreats. They functioned as hubs. Flight logs later showed a steady flow of politicians, academics, business leaders, royalty, and celebrities. Epstein cultivated proximity to influence, rather than affiliation with any single ideology. He donated to scientific institutions. He socialized across party lines. He presented himself as a patron of intellect and progress. The architecture of his life suggested permanence and legitimacy. That impression mattered. It made other things easier to ignore. By the late 1990s, local law enforcement in Palm Beach had begun receiving reports. Teenage girls described being recruited, often by other girls, for massages at Epstein's home. The descriptions were consistent. The ages were troubling. The alleged conduct escalated quickly. Palm Beach police took the complaints seriously. A detailed investigation followed. Detectives interviewed multiple victims. The evidence, by their account, was substantial. And then, the case changed hands. Federal prosecutors intervened. Negotiations began behind closed doors. In 2008, Epstein entered a plea agreement that stunned many involved. He pleaded guilty to 2 state charges: solicitation of prostitution and procurement of a minor for prostitution. He served 13 months. Most of that sentence was spent outside jail. The non-prosecution agreement Epstein secured was unusually broad. It granted immunity not only to him, but potentially to unnamed co-conspirators. The victims were not informed of its terms at the time. a violation later acknowledged by a federal judge. The agreement effectively ended the investigation. How it came to pass remains a central question. The U.S. attorney overseeing the case, Alexander Acosta, later stated that Epstein was presented as belonging to intelligence services, an assertion that has never been substantiated. Others point to Epstein's legal team, which included prominent defense attorneys with deep political connections. What is clear is that the outcome was not typical. In most cases involving multiple underage victims, federal charges escalate. Here, they narrowed. Epstein was registered as a sex offender, but his lifestyle changed little. He continued traveling, he continued hosting, he continued cultivating relationships with institutions and individuals who either did not know or chose not to ask why he had been convicted. Some distanced themselves quietly, others did not. He donated money, he attended conferences, he appeared at private gatherings. The social circuit absorbed the conviction without fully acknowledging it. This is where the case becomes less about one man and more about systems. The Epstein case did not collapse under secrecy. It endured through compartmentalization. Local authorities knew one version, federal prosecutors managed another. Financial institutions saw a client, universities saw a donor, social circles saw a connector. No single actor possessed the entire picture or claimed responsibility for assembling it. The victims, meanwhile, remained fragmented. Many were young, many lacked resources. Their stories were similar but disconnected. Without institutional backing, those similarities carried limited force. The system did not deny them outright, it simply absorbed them without resolution. Speculation has flourished around Epstein's protection, whether legal, political, or intelligence-related. Much of it remains unproven. What does not require speculation is the pattern of deference he received. Investigations slowed, charges softened, access continued. It is possible to explain each decision in isolation: prosecutorial discretion, jurisdictional limits, legal negotiation, resource constraints. It is harder to explain their cumulative effect. A man credibly accused by dozens of minors continued to operate within elite spaces for more than a decade after his first arrest. That is not normal. When Jeffrey Epstein was arrested in July 2019, the arrest itself felt overdue rather than decisive. The allegations were familiar. The patterns were already mapped. What changed was not the information, but the pressure to respond to it. Federal prosecutors in New York charged Epstein with sex trafficking of minors. Unlike the 2008 case, this indictment was expansive. It framed the abuse not as isolated misconduct, but as an organized system sustained over years. Recruiters, residences, transportation, payment, silence. The language mattered, so did the timing. For the first time, Epstein was denied bail. He was held at the Metropolitan Correctional Center in Manhattan, a facility already under scrutiny for overcrowding and understaffing. The judge cited his wealth, private aircraft, and history of preferential treatment as reasons he posed a flight risk. The legal process, at last, appeared to be moving forward, and then it stopped. On August 10, 2019, Epstein was found dead in his cell. The official ruling was suicide by hanging. Within hours, the death became an object of disbelief. The failures were too many. Cameras malfunctioned. Guards fell asleep. Previous warnings about self-harm had been documented. The system that had repeatedly bent around Epstein now appeared unable to hold him. Legally, Epstein's death closed the case against him. Structurally, it opened dozens more. Victims lost the chance to confront him directly. Prosecutors lost their central defendant. The public lost the possibility of a full trial, with evidence tested under oath. What remained were fragments, flight logs, settlement documents, sealed filings, and names appearing in proximity, but rarely in context. The question shifted almost immediately from what Epstein did to who else knew. That question proved harder to pursue. Many prominent individuals had crossed Epstein's path. Some traveled on his planes, some attended his dinners, some accepted his donations, some appeared in photographs that later circulated widely. Proximity, however, is not proof. Investigators faced a familiar limitation. Association does not establish participation. Epstein cultivated ambiguity deliberately. His gatherings mixed donors, academics, politicians, and social figures without clear hierarchies. That blending complicated accountability. Several individuals denied any knowledge of criminal activity. Others acknowledged misjudgment. A few distanced themselves retroactively, stating they had cut ties years earlier. the record remains uneven. Names surfaced. Evidence did not always follow. With the criminal case gone, civil litigation took center stage. Victims pursued compensation through lawsuits, targeting Epstein's estate and, in some cases, alleged enablers. In 2020, the estate established a compensation program. Hundreds of claims were filed. The fund ultimately paid out more than $100 million. The process was designed to avoid litigation, offering survivors financial redress without requiring public testimony. For some, it provided relief. For others, it felt incomplete. Financial settlements do not establish public records. They do not compel disclosures. They do not clarify how abuse persisted across jurisdictions and decades. They close cases without necessarily opening understanding. Attention gradually shifted toward those who had managed, enabled, or protected Epstein. Ghislaine Maxwell, long described as Epstein's closest associate, was arrested in 2020.
A unanimous jury has found Ghislaine Maxwell guilty, facilitating and participating in the sexual abuse of children.
Her trial provided rare courtroom testimony about Epstein's operations. Survivors described patterns of normalization, coercion, and repetition. The jury heard evidence not just of abuse, but of coordination. Yet even this trial had limits. Maxwell was not Epstein. She did not answer for his finances, his immunity agreements, or the breadth of his social access. The prosecution focused narrowly, by necessity. Larger questions remained untouched. Several institutions conducted internal reviews. Universities returned donations. Foundations severed ties. Boards issued statements acknowledging failures of oversight. These responses were careful and controlled. They addressed reputational risk more than systemic vulnerability. Few institutions publicly examined how Epstein gained their trust in the first place, or why background checks, due diligence, and internal concerns failed to interrupt that trust. In most cases, the conclusion was procedural rather than reflective. Persistent rumors suggested Epstein had ties to intelligence agencies. These claims circulated widely after his death, fueled by his unusual immunity, international reach, and access to powerful figures. To date, no conclusive evidence has confirmed these assertions. What can be said is more limited and more troubling in its own way. Epstein did not need intelligence backing to exploit institutional blind spots. Wealth, legal strategy, and social leverage were sufficient. The speculation itself may have distracted from a more mundane reality. Systems often fail without conspiracy. In the months following Epstein's death, coverage surged. Documentaries, articles, podcasts, and books revisited the same material from different angles. The story became omnipresent and then gradually receded. This pattern is not unusual. Sustained attention is difficult to maintain when conclusions are elusive. Without trials, verdicts, or revelations, narratives lose momentum. The Epstein case produced many questions but few definitive answers. As coverage slowed, so did public pressure. Epstein's case is often described as a failure of justice. That description is accurate but incomplete. Justice systems are designed to prosecute individuals, not environments. Years after the initial revelations, survivors continue to speak. Some seek closure, others seek acknowledgement. Many have expressed frustration that the broader system remains largely intact. They describe a recurring pattern, a tension without transformation. Their testimonies have altered public perception, but not necessarily institutional behavior. Reporting mechanisms exist, safeguards have been updated, yet the fundamental asymmetry between power and vulnerability persists. The Epstein case did not invent that asymmetry. It revealed how resilient it is. Key questions remain unresolved. Why did the 2008 agreement go unchallenged for so long? How were decisions justified internally? Who benefited indirectly from Epstein's ability to operate? What warnings were dismissed, and by whom? The record offers partial answers, often buried in footnotes or sealed documents. Transparency has been selective, disclosure has been managed. The absence of a trial ensures that many of these questions will remain hypothetical. In retrospect, Epstein's death marked not a conclusion, but a narrowing. The story contracted around what could be proven rather than what could be inferred. Complexity was reduced to manageability. The discomfort lies in what that reduction leaves out. Epstein's world did not vanish with him. The mechanisms that allowed his rise financial opacity, legal leverage, social insulation continue to operate elsewhere in quieter forms. There is no clear end point to this story, only a lingering uncertainty about how many warning signs were visible, how often they were noted, and how easily they were set aside. Not because they were unbelievable, but because believing them would have required action. And action, in this case, proved consistently inconvenient.